Hey guys, tonight, today, whenever. Short video, hopefully very short. Just talking about the Eighth Amendment real quick. Basically, anything else I wanted to show you was a little bit too long or didn't cover what we needed to. So here we go. So what does the Eighth Amendment say? It says excessive bail shall not be required. One, nor excessive fines imposed. Two, no, nor cruel and unusual punishments inflicted. So no excessive bail, no excessive fines, and basically no excessive punishments. Um, and we tend to skip past the first two and go straight to the third. And so, we'll follow along with everybody else and do the same thing. And this is where we most often talk about, and actually your exam, when it brings it up, most often talks about, and that's the what is it? What does the Constitution say about cruel and unusual punishment? And basically, we jump straight to the death penalty. Um, there's really two cases that we look at when we talk about the death penalty, and for us, they come from Georgia. Um, and so these are cases in the 70s. The first is a 1972 case, Furman versus Georgia. And basically, in the Furman case, Furman was robbing a home. He had a firearm, he had a pistol, and the homeowner was present and apparently came out and confronted Furman or startled Furman. And whatever we know is that Furman, depending on which version of the story he gives, um, turned and ran and either dropped the gun, at which point it fired and struck the homeowner, or as he was running, he sort of blindly fired over his shoulder um, and shot and killed the homeowner. Either which way, you get pretty clear facts. Um, Dude was robbing somebody's house, had a gun, shot and killed the homeowner. And the case goes to trial. Furman is found guilty, and he's sentenced to be executed. And so he appeals. And basically, what we start looking at with this case is not so much, and this is really what Furman sort of built things around. It's not so much the facts of Furman's case in and of itself, but it's how the state of Georgia and, frankly, quite a few states actually enforced the death penalty. If you look at reviews of the death penalty, particularly from that era, the death penalty tended to be much more frequently applied to minorities. So in the South, African Americans, in the Southwest, Hispanic Americans, people with lower education levels, or people that were poorer. Frequently, if you compared white and black perpetrators with very, very similar crimes, the punishments on African Americans were almost always, not always, but almost always harsher. And so basically, he sued on the grounds that Georgia's process was unfair. Okay, and so all of this matters because in this whole section on the Fourth and Fifth and Sixth Amendments, where we're talking about this idea of due process, right? How does the state go about doing things, both procedurally and substantively, right? Are the laws fair and is the process fair? Basically, Furman's going to argue and wins on the idea that Georgia's process isn't fair. It's not equal. And basically, what this does is for about 4 years, you have a moratorium on capital punishment in the United States. So nobody's executed because the way that this ruling comes out is it basically applies across all the states, and it makes states reevaluate how they have their death penalty laws written. Not so much the nature of the death penalty in and of itself. We're going to get to that reckoning later. And so 4 years later, the state of Georgia decides that it is ready to begin enforcing the death penalty or using the death penalty again. And so sentences another man, in this case a guy named Greg, last name, to die. And he, of course, is going to appeal his sentencing based off the Furman ruling. And so goes to the Supreme Court. And in the 1976 case, Greg versus Georgia. And Greg versus Georgia actually ropes in about 5 different state cases together. But basically because Georgia's rewritten its laws and a number of southern states have rewritten their laws, that the death penalty in this case is upheld. And you'll notice they're really not weighing into the moral nature of the death penalty in and of itself. Basically, the court had before and has continued after that to essentially say that in some cases a death penalty is not in and of itself cruel and unusual. Now, the method, how it's being applied, things like that um, can be disputed. So, anyways, here in this Gregg versus Georgia case, again, 1976, the court lays out basically two sets of guidelines in order to have a legitimate capital punishment scheme, and it's all about sentencing. And basically, the criteria for the death penalty must be direct, and they must be clear and objective. And as a part of this, that it basically said that you can't have like a mandatory death penalty for any class of cases. And that all death penalty cases basically will automatically go to appeals. And secondly, the scheme must allow, so in this case, because you can't have it mandatory, you must allow the sentencer, if it's the judge or a jury, to look at the individual case. Like, is this character, what is the character of the person? What is the record of the person? Are there some sort of extenuating circumstances? So if you go back to, the Furman case, going back to the idea of, he either dropped the gun or he's firing over his shoulder. Well, is that, does that rise to the level of like murders with premeditated? He's bringing the gun, planning to kill somebody. So anyways, but the court has to be able to look at all those things and decide. So basically you've got those two requirements. Must be clear, objective criteria, and basically what laws or what violations qualify for the death penalty. And then you must have essentially a little bit of leeway when you're sentencing them. Since then, there's been a whole number of cases that have sort of further kind of limited this. So, for example, this actually also comes out of Georgia. You cannot institute the death penalty in the case of rape, even if that rape involves a child, which is Coker versus Georgia, which I think is an early 80s case. Depending on the level of murder. So in this, again, going back to Furman's case, felony like manslaughter, you can't do it for something like that. It must be proportional. If you're mentally handicapped or juvenile, generally you cannot sentence them to the death penalty either. If you're going to, as a lawyer, if you're going to pursue the death penalty in a case, you pretty much have to allow the entrance of all sorts of evidence, anything that would mitigate the situation. This kind of plays into some of the other things we've been talking about, or that you've been looking at with earlier cases. This idea that basically as the penalty that the state is seeking gets higher and higher and more severe, and of course, the death penalty is the highest penalty that we can go for in a civilized society, right? There's no one doing that one. And so you pretty much have to let all the evidence in. You have to prove things beyond any shadow of a doubt, all of that sort of stuff. So all of those play into our Eighth Amendment case. Sort of going beyond that, generally speaking, a lot of states have moved beyond the death penalty. You've had a number of governors who have converted death penalty sentences into life in prison. And then also we've had a number of court cases around the method of execution. So, death by lethal injection has been challenged a bunch. There's been some rather infamous botched executions here over the last 5-10 years, where instead of the drugs slowing your heart down and limiting breathing and everything else, that somebody's heart exploded or something like that in Oklahoma. And the idea here is that the death penalty is not supposed to be, and the court is actually very clear on this. The death penalty isn't just like you can't needlessly impose suffering. You can argue that somebody did something horrible, and therefore as a state we're going to say that they're going to be executed. But essentially the state's supposed to be above, and by state I mean just government in general. The state is supposed to be above this sort of like retribution punishment. Like, you did something horrible, therefore we're going to make you suffer on your way out the door. No, we are going to do this as our ultimate form of rejection of you participating in civil society. Okay, Now, the other part of the Eighth Amendment is one that gets a little less attention, but is really important because it's what's actually more people are going to encounter, and that's the excessive fines and bails. The whole purpose of bail is to make you show up for trial. An excessive bail is very relative. If you're a very poor person, a bail of $1,000 or $10,000 is that's beyond your means, which means you're going to sit in jail for however long it takes for your court case to play out, which can be months if you're lucky. And if you're very, very wealthy, if they decide to arrest whatever, we won't even use Way's name, but if they arrest a multi-billionaire, even $1 million bail is it's insignificant. And so that part gets debated a lot. There's actually a really important case that just came through, though, about fines and something called civil forfeiture. And this is a 2019 case out of Indiana called Timbs versus Indiana, and I'll actually link to a short news story talking about that. The short version is something called civil forfeiture. And civil forfeiture is where the state basically takes your stuff from you because they believe that your stuff, and this could be an automobile, this could be possessions, were somehow enabling of a crime. That's often how it's a really, sort of Cliff Notes version of all of that. And actually what happens in civil forfeiture is that the state actually files a suit against your stuff, takes your stuff, and then you have to prove that your stuff isn't involved in any crimes, which is a little bit more difficult, it turns out, because it's inanimate objects. So anyways, Timbs versus Indiana, and this was before, civil forfeiture was a big deal because often police departments would seize things from people that maybe have been suspected of a crime, but you couldn't convict them of the crime. So they would seize a bunch of their possessions and then, either keep them or sell them off and use that to fund things, whether that's operations or training trips or whatever else. And so a lot of municipalities and cities, this was big business for them. And so this becomes really a controversial thing because, some places like civil forfeiture, because if they can keep taking, bad people's stuff and funding departments and keeping taxes low, well, of course, everybody's winning, which isn't true. So anyways, Timbs versus Indiana. Timbs was arrested and convicted of selling was less than $500 worth of heroin. So, still serious stuff. But later the police are going to seize his Land Rover, so $42,000 car. Well, does losing a $42,000 car, is that, is that relative to a $500, drug deal? Basically, Timbs is going to argue, of course, no, and he goes to court. And he actually wins, and it goes up to the Supreme Court, and the Supreme Court gives us a unanimous decision saying that this was an excessive fine, that taking the dude's car over such a minuscule crime, particularly by taking it through civil forfeiture, violated his rights. And this was a big deal. So this is a 2019 case. So in 2019, the excessive fines portion of the Bill of Rights was finally incorporated against the states. And that's our most recent example of that process. So hopefully this has all made the Eighth Amendment a little more clear. If not, be sure to let me know, and hope this helps. Take care.